Hi everyone, welcome to Impact Academy. So let us continue with the Indian polity. So today let us look at the Indian judiciary. So the Supreme Court. Every judge of the Supreme Court, after consulting the Chief Justice of Supreme Court, is appointed by the President of India. So we've already seen, right? The Supreme Court, High Court, okay, Chief Justice and all the judges, everyone is appointed by the President. So in appointment of the Chief Justice of India, President can consult such judges of the Supreme Court and the High Court as he thinks appropriate. So President can consult such judges of the Supreme Court and High Court. So a person is qualified for appointment as a judge of the Supreme Court. Okay, so these are the qualifications. First thing is a citizen of India, has been a High Court judge for at least 5 years, has been advocate of a High Court or two or more courts in succession for at least 10 years. So these things try to remember because they are sometimes asked in the questions. So citizen of India, you can just look at the answer and say, so that's not the problem. So remember this. Okay, if you want to be a judge of the Supreme Court, you have to have been a High Court judge for at least 5 years. So, in order to become a judge of Supreme Court, already you should be a judge in High Court for at least 5 years, or if not judge, then advocate of a High Court or two or more courts in succession for at least 10 years. This is Article 124. Okay, Article. So we have seen. So chapter 4 is judiciary. Okay, so this we are talking about in the chapter 1, 2, 3, 4 of part 5. So in the part 5 it deals with the union. We've seen part 6 deals with the state. Okay, so with that chapter 4 is Indian judiciary, union judiciary. So 124 is very important. 124 is establishment and constitution of Supreme Court, and 214, what is this? 214 is high courts. Chapter 5. Chapter 4 is union judiciary, and chapter 5 is high courts in states. That is 1 to 4. This is 214. So easy to remember. Okay. High court of state is 214 and 124. 124 is union judiciary. And all these things are important. So this 124A is establishment of National Judicial Appointments Commission that has been declared unconstitutional by the Supreme Court, but however not repealed by the Parliament. But it is not in use, you can say. So some of the important things: 130 seat of Supreme Court. Next to this, 131 is more important. Original jurisdiction of the Supreme Court, that is very important. And we've already seen appellate jurisdiction of Supreme Court in appeals from high courts in certain cases. Okay, this is also very important. So we've seen this 136, right? Special leave to appeal by Supreme Court. So 136 is very, very important. So whatever the case may be anywhere, you can go to the Supreme Court by special leave. Okay. So, but this is very expensive affair. Not everyone can go. Next, 142 is enforcement of decrees and orders of Supreme Court, and orders has to discovery. And 143 is power of president to consult Supreme Court. So all these are very, very, very important. 142 is very important. 143 very important. 136 special leave. 131 original jurisdiction. Okay, and 132 is appellate jurisdiction. That means if a particular high court gives any order, even then you can go to the Supreme Court as an appeal. Okay, so all these are very, very important. 124 is the establishment of Supreme Court. So try to remember all these articles. So in a point, all these things we have seen. So there is no minimum age or fixed period of office prescribed for appointment as a judge of the Supreme Court. So there is no minimum age or fixed period. A judge of the Supreme Court ceases to be so on attaining the age of 65 years. Okay. So after attaining the age of 65 years, so try to remember all these things. Okay, ages 65 years, resigning in writing address to the president. Okay, so if the president wants to resign, he has to address to the vice president, and because president is the appointing authority for the Supreme Court judges, they are addressing to the president. Okay, resigning in writing addressed to the president. Here in the question they might ask resigning in writing addressed to the Chief Justice of India. Okay, so that might look like seems like yes, maybe correct, right? But no. So try to remember all these things. Who gives the oath? Who appoints? Who resigns? Okay. So while resigning, Supreme Court judge has to address to the president. On being removed by the president, okay, the only grounds for such removal are proven misbehavior and incapacity. Only once there has been a resolution, but even that was not passed, I think. So no Supreme Court or High Court judge has been ever impeached so far. So procedure for removal or impeachment of a Supreme Court judge. A motion addressed to the president, signed by at least 100 members of the Lok Sabha or 50 members of the Rajya Sabha, is delivered to the speaker or the chairman. Okay, so remember this. So motion first addressed to the president, signed by at least 100 members if it is Lok Sabha, okay, 50 if it is Rajya Sabha. Then the motion is investigated by a committee of three, two judges of the Supreme Court and a distinguished jurist. Okay, if the committee finds the judge guilty, report of committee is considered in the house where the motion is pending. Next, if the motion is passed in each house by majority of total membership of the house and by majority of not less than two-thirds of the members present and voting, and the address is presented to the president, basically special majority. So it has to be passed by special majority. So removing the judge is not easy. So the judges have a lot of protection. So the judge is removed after the president gives his order for removal on such address. So it can be removed by the president only. The procedure for impeachment is the same for judges of Supreme Court and the High Courts. So even High Court judges are appointed by the president, and the procedure is also same. So after retirement, a judge of the Supreme Court cannot plead or act in any court or before any authority within the territory of India. Okay, so once he retires, he cannot plead or act in any court so that to avoid any conflict of interest. Jurisdiction of the Supreme Court is threefold. So original jurisdiction, Article 131 we have seen, appellate 132, and advisory Article 143. Okay, so in 131 we have seen it is original jurisdiction. 132 is appellate jurisdiction. Then 143 is power of president to consult the Supreme Court. Okay, whenever the president has any doubt regarding anything, he can consult the Supreme Court, and Supreme Court will give advisory not only to the president, but in general it can give advisory jurisdiction also. So disputes between different states of the union or between the union and any state is within exclusive original jurisdiction of the Supreme Court. Okay, such questions are frequently asked. Try to understand. So dispute between different states or between union and any state is within exclusive original jurisdiction of the Supreme Court, because if it is between different states, so there is going to be one high court there, one high court here. So if original jurisdiction is with the high court, okay, so original jurisdiction is directly you can go to that particular court. Okay, appellate means through appeal. So if there is appellate jurisdiction of the Supreme Court in certain matter, first you have to go to the high court. The high court will give an order. Then to appeal that order, saying that you're not satisfied with the order, you can go to the Supreme Court. That is called appellate jurisdiction. And special leave to appeal is Article 124, right? We have seen all that. Okay, is it 124? Let's quickly check. Sorry, 136. Okay, so 136. Try to remember. Special leave to appeal by the Supreme Court is 136. This is a very important power for the Supreme Court. So any case can be referred to the Supreme Court with the help of this. And 141 is also very important. Law declared by Supreme Court to be binding on all courts. So that is why in India we say we have a unified judiciary. So between any states, so if you have original jurisdiction to the high courts, then the high court in which that particular state is there might face difficulty in dealing with the high court of another state. So any dispute between states or between union and the state always goes directly to the Supreme Court, original jurisdiction. The jurisdiction of the Supreme Court to entertain an application under Article 32, that is the writ jurisdiction, habeas corpus, mandamus, prohibition, certiorari, all those things. For the issue of writs for the enforcement of fundamental rights is treated as the original jurisdiction of the Supreme Court. So, so Article 32 is called as writ jurisdiction, but that comes under the original jurisdiction of the Supreme Court, because for these writs you can go directly to the Supreme Court. Even High Court has writ jurisdiction, okay, but the writ jurisdiction of Supreme Court, that also is a frequently question. Okay, the writ jurisdiction of High Court is actually more wider. We'll look into that. The Supreme Court is the highest court of appeal from all courts in the territory of India. It is the highest court of appeal. Supreme Court is the highest authority for interpretation of the Constitution. So all these are very important statements. Okay, Supreme Court may hear appeals by granting special leave against any kind of judgment or order made by a court or any tribunal except a military tribunal. Okay, so this is Article 136. We have seen, right? Special leave to appeal. So Supreme Court is having this appeal jurisdiction, special leave to appeal by granting special leave against any kind of judgment or order made by any court or tribunal. So any high court or any district court, if they give any order, okay, they say suppose a person goes and the high court gives an order for the municipal corporation to bring down the building because he has violated something. Then he can go to the Supreme Court through appeal and he can get a stay order. Okay, so that case, then once it goes to the Supreme Court, it is no longer in the court in the lower courts. Okay, whatever the Supreme Court says is binding on all the courts, and that we have seen 141 law declared by Supreme Court is binding on all courts. Okay, but also these loopholes are sometimes used, especially by rich people and powerful people, to drag the cases for many numbers. So that is one of the biggest problem that is being faced by the Indian judiciary right now is too much time period. Okay, there is no fixed period. So for 20 years, 30 years, the cases are being dragged, and denial of justice is also what you can say. Delay of justice is also denial of justice, right? So in the mains also you can write that one of the problem the judiciary is facing right now is delay, very inordinate delay. So anyway, remember this, except a military tribunal. So okay, military tribunal, that's a different thing. Okay, we have seen already the defense forces, they have this court martial procedure. So the normal courts do not interfere in the military. So even if a military person, what you say, I mean, sometimes we have seen on the news, right? Some fights break out and someone who's from the military, they get into a fight, and I've seen one case where the military person also kills the person also, but he will not go to the normal courts. He will go to the military courts, and he will get court martialed. Okay, so remember that. Except a military tribunal, any other court or tribunal, the Supreme Court has the power to appeal. Under advisory jurisdiction, Supreme Court can give its opinion on any matter of law or fact of public importance referred to it by the President. So Article 143. Very important. This is the advisory jurisdiction. Now let us look at the High Courts. So the High Court is the head of the judiciary in the state. Every judge of a High Court is appointed by the President. Remember this very clearly. He is not appointed by the Chief Justice of India or Chief Justice of the High Court. He is appointed by the President. And if he wants to resign, he has to give the resignation to the President only. In making appointment as High Court judge, President can consult the Chief Justice of India, Governor of the state, and also Chief Justice of the High Court. Okay, so in order to make appointment as a High Court judge, the President consults Chief Justice of India, Chief Justice of that particular High Court, and the Governor of the state. So a judge of the High Court can hold office up to 62 years. So in the case of Supreme Court, we have seen 65 years, right? A High Court judge can leave his office by resignation in writing address to the President, by being appointed as a judge of the Supreme Court, or being transferred to any other High Court by the President, by removal by the President. The mode of removal of a judge of a High Court is same as that of the judge of the Supreme Court. Okay, very lengthy procedure. 100 resolution with 100 members from Lok Sabha, 50 members from the Rajya Sabha, either that or this. Okay, and that has to be passed by a special majority, and then it has to go to the President. All that we have seen. So qualifications. So be a citizen of India, not above 62 years of age, must have held for at least 10 years a judicial office in territory of India or experience of at least 10 years. So there we have seen that must have at least 5 years as a judge of High Court. So in order to be a judge of High Court, you should already have 10 years of experience, at least 10 years as advocate of a High Court. So indirectly, even for Supreme Court, you have to have 10 years of some experience in the High Court or any other court. Okay, indirectly, because at least 5 years of High Court judge you have to become. But in order to become High Court judge itself, you need to have 10 years. So overall, in order to become Supreme Court judge, you have to have indirectly minimum of 15 years of experience, right? Indirectly. But otherwise, 10 years of continuous advocate, and 5 years of judge as the High Court. That is, we have seen in the Supreme Court. In this case, you have to have 10 years as a judicial office in territory of India, experience of at least 10 years as an advocate of a High Court. Okay. So salaries and allowances of the High Court judges are charged on the consolidated fund of the state. So there is no separate voting for it. Okay, so consolidated fund of the state, Article 202. So after retirement, a permanent judge of the High Court cannot plead or act in a court or before any authority in India except the Supreme Court and the High Court in which he has not worked. So if it is the judge of the Supreme Court, he cannot go anywhere as a lawyer. Okay, but if he is a High Court judge, then he can go as a pleader in a Supreme Court or any other High Court also in which he has not worked. So that is one difference between High Court judge and Supreme Court judge. So just have a brief look about this. So High Courts and seats and jurisdiction. So which is the oldest High Court? 1866, Allahabad, right? Uttar Pradesh, Allahabad bench at Lucknow. So this is the oldest, just remember. And Andhra Pradesh is also 1954. Okay. So Andhra Pradesh High Court 1954. Right now it is in Amravati, right? Amravati. After the state has split. So all these things just go through. So one of the latest one you can say is 1975. Okay. Okay. 2000 Chhattisgarh. 2013. So latest is this Manipur, Meghalaya, Tripura. Okay. 2013. Very recently they have had high courts established. Okay. So now let us look at the difference between the Supreme Court and the High Court briefly. So Supreme Court we have already seen part 5. Okay, High Courts is part 6. Very important. Part 5 is Supreme Court. Part 6 is High Court. Because part 5 is the union and part 6 is the state. Okay, Article 124 to 147. Try to at least remember 124. Very important. And here we have seen 214. Just jumbling of this 214 to 231. Next, Supreme Court inaugurated on 20th Jan 1950. Single system of courts adopted from the Government of India Act of 1935. So we have a single system of courts. Okay. In mains, frequently this question comes. They are described of the federal features or unitary features. Okay. So one of the unitary feature you can see is the single judiciary. So for whole of India, Supreme Court is the highest authority. So Supreme Court replaced British Privy Council in 1950. So Constitution declares Delhi as a seat. However, Chief Justice of India can appoint other places as seats also. Okay. A Parliament cannot curtail jurisdiction of Supreme Court. However, Parliament can extend the jurisdiction of Supreme Court. So it cannot curtail the jurisdiction. So Parliament cannot say that okay, from tomorrow Supreme Court will not have any powers in Andhra Pradesh. No, it is not possible. But Parliament can extend the jurisdiction. Supreme Court is the custodian of the Constitution of India. Very, very important. Okay, the final interpreter of the Constitution and all that is Supreme Court. So the institution of High Court originated in India in 1862. And the High Courts were set up at Calcutta, Bombay, and Madras. In 1866, fourth High Court was established at Allahabad. Okay, so currently you can say the High Court at Allahabad is the oldest one because this Calcutta, Bombay, and Madras, they've I mean they were 1862. Okay, so you can say 1866 fourth High Court. So already 1862 we have these High Courts, right? Calcutta, Bombay, and Madras. So they are more older. Remember that Calcutta, Madras, and Bombay, the High Courts are 1862, and Allahabad High Court is 1866. So Allahabad is not the oldest. We've seen there. Fine. So the Constitution of India provides for a High Court for each state, but the 7th Amendment Act of 1956 authorized the Parliament to establish a common High Court for 2 or more states, or for 2 or more states and a union territory. So at present, 2019, there are 25 High Courts in the country. Okay. So we have 28 states, but we have 25 only High Courts. That means there are few states which do not have a High Court. Fine. So, and the 7th Amendment Act of 1956, 7th Amendment Act of 1956 authorized the Parliament to establish common High Courts, like for Punjab and Haryana, etc. Also for a union territory. For example, Chennai High Court will also have jurisdiction over Andaman and Nicobar. Okay, Lakshadweep in Kerala High Court, like that. So composition and appointment of Supreme Court judges. So 2019 Center notified increase in the number of Supreme Court judges from 31 to 34. So including the Chief Justice. So including the Chief Justice, right now there are 34. Okay, judges of the Supreme Court are appointed by the President. Chief Justice is appointed by the President after consultation with such judges of the Supreme Court and High Courts. The other judges are appointed by President after consultation with the, we've already seen, Chief Justice of India, okay, Chief Justice of Supreme Court, and such other judges and High Courts. Okay, the other judges are appointed by the, this we are talking about the Supreme Court, right? So there are, after consulting with Chief Justice and other such judges of the Supreme Court and the High Courts. Okay, the consultation with the Chief Justice is obligatory in the case of appointment of a judge other than the Chief Justice. Okay, so only in the case of Chief Justice, you there because you're what you say appointing Chief Justice, there is no what you say, you cannot consult with him. In all other cases, you have to consultation. You have to take consultation of the Chief Justice. Next, third justice case, consultation of plurality judges. Okay, the third justice case is regarding the consultation of plurality judges. Fine, no problem. So composition and appointment of High Court judges. So every High Court, whether exclusive or common, consists of a Chief Justice and such other judges as the President may from time to time deem necessary. Okay, here in this case, right now the 34 is fixed. In this case, the President will decide. Constitution does not specify the strength of a High Court and leaves it to the discretion of the President. So in the Constitution, there is nothing mentioned about the strength. So the judges of High Court are appointed by the President. Chief Justice is appointed by the President after consultation with the Chief Justice of India, Governor of the state concerned. We've already seen this. Okay, Chief Justice of India and the Governor of state concerned, after discussing with them, the Chief Justice of particular state is appointed by the President. So for any judge, we've seen Chief Justice of India, Chief Justice of the High Court, and the Governor. So in 2015, Supreme Court declared both the 99th constitutional amendment as well as the NGSC Act as unconstitutional and void. Okay, the National Judicial Accounts Committee, appointment committee. So basically, the Parliament wanted to bring in some members from the Lok Sabha, etc. Also in the right now we have a collegium system, right? So judges select the judges. Okay. So there is some criticism on that point, and the Parliament tried to bring in a mix of what is parliamentarians and judges combination to select the judges, but that was declared null and void. Okay, so the judiciary is an independent organ of the administration, right? So they won't tolerate any interference from outside. So qualification of judges. So citizen of India. So we have seen in the case of Supreme Court, it is 65 years. In the case of High Court, it is 62 years. Okay. So citizen of India common, he should have been judge of a High Court for 5 years, or should have been an advocate of High Court for 10 years. So in the case of High Court, should have held a judicial office in the territory of India for 10 years. Should have been an advocate of a High Court for 10 years. So you should be a distinguished jurist in the opinion of the President. So anyone who is in the opinion of the President a distinguished jurist, he also can be appointed as the judge of the Supreme Court. Constitution has not prescribed a minimum age for appointment as judge. There is no minimum age, but maximum is 65. Constitution makes no provision for appointment of distinguished jurist as the judge of High Court. Okay, so if the President wants, he can appoint a distinguished jurist in the Supreme Court, but not in the case of the High Court. So if you look at the oath, has to make and subscribe an oath or affirmation before the President. So has to make and subscribe an oath or affirmation before the Governor. So appointment is done by the President and oath is given by the President in the case of Supreme Court. But in the case of High Court, appointment is given by the President, but oath is administered by the Governor. Try to remember this because there is a change. Such a question can be asked. So the Constitution has not fixed the tenure of a judge. Okay, there is no fixed tenure. He holds office until he attains the age of 65 years. Question regarding age can be determined by Parliament. He can resign by writing to the President. He can be removed from his office by President on the recommendation of the Parliament. Okay, on the grounds of misbehavior and proven incapacity. And we have seen resolution with 100 from the Lok Sabha or 50 from the Rajya Sabha. Okay, and here Constitution has again not fixed the tenure. Here it is about 62 years, 65, 62. Try to remember that. He can resign by writing to the president, not to the governor or chief justice. Okay, both cases president. He can be removed from his office by the president on the recommendation of the parliament on grounds of misbehavior or incapacity. So whether it is a High Court judge or the Supreme Court judge, he has to go to the impeachment procedure. Simply, you cannot remove him. Okay. So the Judges Enquiry Act 1968 regulates the procedure. A removal motion signed by 100 members in the case of Lok Sabha, 50 members in the case of Rajya Sabha. Speaker or chairman may admit the motion or refuse to admit it also. After the motion is passed by each house of the parliament by special majority. Again, remember, not so simple. Okay, special majority. An address is presented to the president for removal of the judge. So no judge of the Supreme Court has been impeached so far. Only once a motion has been admitted, but later it has been removed. Okay. So a judge of High Court can be removed from his office by a order of the president. A removal motion signed by 100 members in the case of Lok Sabha, 50 members in the case of Rajya Sabha is to be given to the speaker. After the motion is passed by each house of the parliament, again by special majority, address is presented to the president for the removal of the judge. The procedure for the impeachment of a judge of the High Court is same as that of the judge of the Supreme Court. The president can transfer a judge from one High Court to another after consulting the Chief Justice of India. Next, acting ad hoc and retired judges. Acting Chief Justice. The President can appoint a judge of the Supreme Court as the acting Chief Justice of India. Okay, when the office is vacant or CJI is absent or is unable to perform due to health issues or anything, then the President can appoint any judge of the Supreme Court as the acting Chief Justice. So, ad hoc judge. So, when there is a lack of quorum in the permanent judges to hold that or continue the session of the Supreme Court, so 34 are required. Suppose there are too low and the number of cases are too high, the Chief Justice of India can appoint a judge of a High Court as the ad hoc judge of the Supreme Court for a temporary period. And who is appointing this? Chief Justice of India, not the President. See, active Chief Justice. So, acting Chief Justice is done by President. Ad hoc judge is done by Chief Justice of India. Retired judge. Okay, at any time, the Chief Justice of India can request a retired judge of the Supreme Court or a retired judge of a High Court to act as a judge of the Supreme Court for a temporary period. Okay. So, ad hoc judges and retired judges, we are talking about Chief Justice. He has the power. Acting Chief Justice, in that case, because the Chief Justice himself is not able to perform, President will appoint. Similarly, acting Chief Justice of High Court, President can appoint a judge of the Supreme Court as the acting Chief Justice of High Court. So, in this case, obviously, judge of the Supreme Court here also can appoint a judge of the Supreme Court. Okay, if you want to, if the Chief Justice of the High Court is not there, then a judge of the Supreme Court is appointed as the acting Chief Justice, not the judge of the High Court. Additional and acting judges, President can appoint duly qualified persons as additional judges of a High Court for a temporary period not exceeding 2 years. Okay, in this case, he can appoint a judge of a High Court. So from the High Court, you can make him a Supreme Court for temporarily. In this case, already we are talking about the High Court. So any duly qualified persons. Retired judges. At any time, Chief Justice of a High Court can request a retired judge of the High Court or any other High Court to act as a judge of the High Court for the temporary period. So even retired judges, you can bring them back and act as a what you say, higher judges. So if you look at the jurisdiction and powers of Supreme Court, original jurisdiction we have already seen under Article 131, right? 131 is original jurisdiction, 132 is appellate jurisdiction. Subject to the provisions of this constitution, Supreme Court shall, to the exclusion of any other court, have original jurisdiction of any dispute between the government of India and the states, between the government of India and any state, or states on one side and one more on the other, states on the other, or between two or more states, insofar the dispute involves any question on which existence or extent of a legal right depends. Anyway, as we have seen, it is between the government or one state or state or union territory, etc. So all these things come under the original jurisdiction of the Supreme Court. Okay, the Supreme Court has exclusive original jurisdiction in the above cases. Exclusive means no other court can decide such disputes, because if there are two states involved, two states will have two high courts, so there is going to be a clash. And we are not talking about appeal. So if it goes by way of appeal, then that is appellate jurisdiction. So original jurisdiction does not extend to pre-constitutional treaties, interstate water disputes, and matter referring to finance commissions. So when it comes to interstate water disputes, for that you have separate tribunals, and finance commission again, president will appoint. Okay, so only in these pre-constitutional treaties, interstate water disputes, and matter referring to finance commission, there is no original jurisdiction. Next, jurisdiction and powers of High Court. Original jurisdiction means it has the power of High Court to hear disputes in the first instance, not by the way of appeal. So, matters of admiralty and contempt of court, disputes relating to election of members of parliament and state legislature. So, election related of this MLA and MP, it goes to the High Court. Remember that. Regarding revenue matters or act ordered or done in revenue collection. So, enforcement of fundamental rights of citizens. So, in case of fundamental rights also, first you can go to High Court. Even High Courts have original jurisdiction. Even Supreme Court has original jurisdiction in case of fundamental rights. Okay. So cases ordered to be transferred from a subordinate court involving the interpretation of the constitution to its own file. Okay, so if a district court is looking after some case and it requires some form of interpretation of the constitution, then so High Court has original jurisdiction. So if we talk about writ jurisdiction, which is very important, the Supreme Court has original jurisdiction in the sense that aggrieved citizen can go directly to the Supreme Court. Okay, Article 32. So, if you want to go for any habeas corpus or mandamus or any of those things, you can go to the Supreme Court directly. So, it has original jurisdiction. Okay, not necessarily by way of appeal. However, the writ jurisdiction of the Supreme Court is not exclusive. Okay, Supreme Court can issue writ only for the enforcement of fundamental rights. But if you look at the writ jurisdiction of High Court, it is more wider. Okay, here it is Article 32. Here it is Article 226. Article 226 of the Constitution empowers the High Court to issue writs. The writ jurisdiction of High Court is not exclusive but concurrent with the writ jurisdiction of the Supreme Court. Okay, both cases it is not exclusive. So, in the same issues like fundamental rights, both High Courts can issue or Supreme Courts can issue. But the writ jurisdiction of High Court is more wider. Okay, so if you look at appellate jurisdiction, it enjoys a wide appellate jurisdiction which has classified under four heads. Okay, in Supreme Court, appeals in constitutional matters, appeals in civil matters, appeals in criminal matters, appeals by special leave. So all these things come under the appellate jurisdiction of Supreme Court. So High Court is primarily a court of appeal. That means first you have to go to the district court, and on top of that, then you will go to the High Court. So primarily a court of appeal. So it hears appeals against the judgments of subordinate courts like the district courts, municipal courts. Okay, several tribunals, everything. So every small thing you need not go to the High Court. First you go to the local tribunal or local High Court, and then you go as an appeal you will go to the High Court. It has appellate jurisdiction in both civil and criminal matters. Next, supervisory jurisdiction. A High Court has the power of superintendence over all courts and tribunals functioning under its territorial jurisdiction, except military courts and tribunals. So military as it is, no one has any power. So all other courts and tribunals, so High Court have power over that. And on top of the High Court, Supreme Court has more power. So if you are talking about the advisory jurisdiction of the Supreme Court, we already seen Article 123, right? It authorizes the President to seek opinion of the Supreme Court in two matters, majorly on any question of law or a fact of public importance which has arisen or which is likely to arise. Supreme Court may tender or may refuse to tender also. So all these are very important. Questions can be asked. Okay. So when the president wants to ask the Supreme Court on what issues he is going to ask, anything about any law or any fact of public importance, okay, or any dispute arising out of pre-constitutional treaties or agreements. Now, in the case of any law, the Supreme Court may or may refuse. But when it comes to pre-constitutional treaty or agreements, Supreme Court must tender its opinion to the president. Okay. So, a lot of questions can be asked from this section. Okay, so try to be very clear. Two categories president may request. One is any law or fact of public importance. Here Supreme Court may or may not give. But if it is regarding pre-constitutional treaty or agreement, Supreme Court must tender its opinion. Okay, very important. Next, power of judicial review. So judicial review is the Power of the Supreme Court to examine constitutionality of legislative enactments, executive orders, and etc. So that's the fundamental thing. Constitutional interpretation. Supreme Court is the ultimate interpreter of the Constitution. Other powers of the Supreme Court, it decides the disputes regarding the election of the president and the vice president. Okay. So election of MPs and MLAs is going to the high courts. Election of president and vice president, any dispute will go to the Supreme Court. It inquires into the conduct and behavior of the chairman and members of the Union Public Service Commission. Okay, it has the power to review its own judgment or order. So we have seen in the case of what is the Golaknath case, right? There was a review of its own judgment. In the Golaknath case, initially in the Shankari Prasad case, okay, 1951, they said you can amend the fundamental rights. Again, in Golaknath case, they said you cannot amend the fundamental rights. Again, in Keshwananda Bharti, they said you can amend anything, okay, except the basic structure. Okay, so it has the power of judicial superintendence and control over all the courts and tribunals functioning in the entire territory of country. So important articles 124. A National Judicial Appointment Commission has been declared void. Okay, 124 is establishment of Supreme Court. 130 is seat of Supreme Court. 131 is original jurisdiction. 132 is applied jurisdiction. 136 is by way of appeal. 141 law declared by Supreme Court to be binding on all courts. 142 enforcement of decrees and orders. Okay, enforcement of decrees and orders. 143 is power of president to consult the Supreme Court. Fine. So here, if you look at power of judicial review, power of High Court to examine the constitutionality or legislative enactment of both central and state governments. Judicial review is nowhere being used in the Constitution. Okay, this also try to remember. But the provisions of 13 and 226 explicitly refer to the power of judicial review. Okay, so all this is fine. So court of record. As a court of record, High Court has two powers. The judgments, proceedings, and acts of the High Court are recorded for perpetual memory and testimony. These records are admitted to be evidentiary value and cannot be questioned when produced before any subordinate court. So even Supreme Court is a court of record and High Court is also court of record. It has the power to punish for contempt of court, okay, either with simple imprisonment or fine or both. So the expression contempt of court has not been defined by the Constitution. However, the expression has been defined in the Contempt of Court Act of 1971. So important articles regarding the High Court. We have seen Article 214, right? So starting one, 214 is High Courts, okay, establishment of High Courts, and 215 is High Court to be a court of record. Next, we have seen 222 transfer of judge from one High Court to another, appointing of all these things. Power of High Court to issue certain writs. So 226 is very important. Writ jurisdiction. For Supreme Court, it is Article 32, and here it is 226, and extension. All this is fine. So 231 establishment of Common High Court. So we have already seen, right? 7th Amendment Act, okay, of 1957. All those things we have seen. So important articles 227, 222 is transfer of judge from one High Court to another. 227 power of superintendence over all courts by the High Court. So judicial review is more important. We'll look into that. So that is about the Supreme Court and the High Court. So we have covered in depth about the Supreme Court and the High Court. Fine. That's all.